For months now, the litigation in the disputed Edo State Governorship Election Petition Tribunal has been on. Recently, the Court of Appeal sitting in Abuja upheld the decision of the trial court that affirmed the election of Senator Monday Okpebholo as the duly elected governor of Edo State. Now the certified true copy of the judgment is out. Our senior reporter, Best Orator, in this special report is revisiting the issues determined by the Court of Appeal.
Any moment from now, the Supreme Court, which is the apex in the judicial system, we begin hearing in the appeal filed by the candidates of the People's Democratic Party in the September 21 Edo governorship election. Dr. Asweleme Igodalo are praying the Supreme Court this time to nullify the election of Senator Monday Okpebholo and declared him as the winner of that election. Well, it is a common knowledge that the appeal court on 29th of April 2025 had affirmed the decision of the trial court tribunal that affirmed the election of Senator Monday Okpebholo as the duly elected governor of Edo State. And now, dissatisfied by this decision, the PDP and its candidates are now proceeding to the Supreme Court. Well, like it is said, the court does not give what you do not ask for. For the appeal court and even the tribunal, they have said that the petitioners have failed to prove their case of non-compliance and other issues brought before it. And so in this special report, we are delving into the certified true copy of the recently delivered judgment of the Court of Appeal that sat in Abuja. There were three issues identified by the Appellant Counsel for determination by the Court of Appeal. Firstly, the appellants wanted the appeal court to determine that whether, having regard to the pleading of the parties, the applicable laws and judicial precedent, the tribunal was wrong when it rejected the oral and documentary evidence led by the appellant as proof of facts of non-compliance with the provisions of Section 73(2) and 51(2) of the Electoral Act 2022, and in holding that the appellant did not prove ground one of the petition. Secondly, whether, having regard to the pleadings of the parties, the quality of evidence led by the appellant, and the state of the law as laid down by the Supreme Court, the tribunal was wrong to hold that the appellant did not prove their case of collation of incorrect scores, exclusion of the results of 75 polling units, and that the appellant did not prove ground one of the petition. And lastly, whether, having regard to the pleadings and upon a proper evaluation of the evidence and the correct application of the law, the tribunal was wrong when it dismissed the petition. In the view of the appellant, there was no need for the testimony of eyewitnesses on the point that requisite forms were filled and that tribunal was in error when it held that the exhibits were dumped on it. They insisted that oral evidence was not necessary to prove the case of the appellant. The PDP complained that the tribunal discountenanced statutorily mandated forms. Determining the grounds of the petition, Justice Olabode Abimbola Adegbehigbe, who read the judgment and the position of the Court of Appeal, said the position of the tribunal in dismissing the petition represents the current state of the law, going by the standards set by the Supreme Court, and until those standards shift or are shifted, all lower courts in the judicial hierarchy are mandated to follow the trace set by the Supreme Court. He said the tribunal was right in its decision to dismiss the case of the appellant on the basis of the reasons given in its judgment, and that the exercise may take some time and space. The court said the appeal of the appellant gravitates around whether or not a particular form EC25B was filled with appropriate information as claimed by the appellant to satisfy the requirements of Section 73(2) of the Electoral Act 2022, and that the respondent's case was that all forms were filled in requirements of the section, and that the appellants failed to tender Form EC25B, which is the most opposite form envisaged by Section 73. The court said it is glaring that from the provisions of Section 73, that where the admitted document relied on to prove the alleged non-compliance with a provision of the Electoral Act does not on its face manifest it, then oral evidence must be called to prove it, that the Forms EC8B, EC8C, and EC40G, and other documents tendered by the petitioners to prove their allegations of overvoting, non-accreditation, non-holding, and cancellation of election do not manifestly disclose any of the non-compliance alleged by the petitioners, adding that there was therefore need for the petitioners to call oral evidence concerning the documents tendered. The court said the tribunal correctly decided that the documents were dumped and correctly refused to accord them probative value, adding that it was glaring that the petitioners failed woefully to produce evidence that established overvoting, non-holding, or cancellation of election results and non-accreditation of voters. It concluded by saying that PW2, PW3, PW4 to PW10, not being polling unit agents, were not competent witnesses to testify in the first place regarding whether or not the forms in question were properly filled or not filled at all. It added that notwithstanding the provision of Section 137 of the Electoral Act 2022 and paragraphs 46(4) of the first schedule to the Electoral Act 2022, the petitioner is obligated to demonstrate with cogent and unassailable oral evidence clearly demonstrating the alleged non-compliance. The petitioners must not sit and merely predicating reliance upon the provisions of Section 137 of the Electoral Act 2022. The Court of Appeal said besides the BVAS machines that were clearly dumped on the tribunal without being demonstrated in any space or form, that PW7 merely identified them and asked the question on what basis could the trial tribunal have made its findings on the issue of overvoting. Addressing the second issue, the Court of Appeal said the appellants were fixated on the fact that it is Form EC25B which must be filled with all particulars of inspected sensitive materials prior to the commencement of polls. It maintained that it is imperative to state that there is nowhere it is stated that details of BVAS machines should be recorded in forms in the polling unit booklets prior to the commencement of polls, contrary to the muscularly aggressive contention of the appellants. In the certified copy of the Court of Appeal, the court noted that the appellant's case was built on avoidable false premise to the effect that the form to be filled is Form EC25B, whereas in the same booklet they tendered, there is glaring evidence of compliance in Exhibit EC40A and in other form. In these circumstances, the decision of the tribunal, according to the Court of Appeal, where it held that appellants failed to prove non-compliance with Section 73(2) of the Electoral Act 2022 cannot be faulted, but it is sound. The Court of Appeal said in the circumstances, the only duty that the court has to discharge, having confirmed that the tribunal diligently and correctly discharged its duties in trying appellant's petition in accordance with the law, is to hold and thereby held that the tribunal correctly held that the appellants failed to prove ground 1 in their petition. And ground 1 having failed according to the court, there is no way the second issue may be resolved in favor of the appellants to the effect that the appellants will now score majority of the lawful vote cast at the governorship election in view of the outcome of the first issue in the appeal. It maintained that the tribunal was right to have taken the decision it arrived at. The appellants were wrong to have insisted that the tribunal is wrong. He stated that the law still remains that the petitioner who contests the legality or lawfulness of votes cast in an election and the subsequent result tendered in evidence or the necessary document by way of forms and other documents used in the election, which must be legible, he should not stop there. He must call witnesses to testify. The witnesses must be those who saw it all on the day of the election. The appeal court said the case of the appellants was inadequately presented through 19 witnesses who did not witness what they testified about, and the absence of hard copies of Forms EC8A, which is the primary document in the process of verification of results. Therefore, the complaints about wrongful collation of scores cannot be properly treated, and that the document downloaded from IREV are strictly meant to verify or confirm what is contained in the physical result of hard copies. It says that the law is clear that where a party decides to rely on documents to prove its case, there must be link between the document and specific areas of the petition. The Court of Appeal said the appellants failed abysmally to prove their claim of having won majority of lawful votes cast at the election, and that the appellants were not even sure or certain about the figures that the party scored at the election and did not prove same at the trial because they did not demonstrate in the open court how figure was arrived at as the scores of the parties which contested the election through any witness. On issues number 3, whether having regard to the pleading upon proper evaluation of evidence and the correct application of the law, the tribunal was wrong when it dismissed the petition. However, the Court of Appeal said that the petition of the appellants was properly determined and therefore dismissed the appeal. for lacking in merit. One of the issues that the Court of Appeal looked at during the judgment was the preliminary objection of the cross appeal by the second respondent, Senator Monday Okpebholo. The appellant had argued that grounds 1 to 4 of the notice of cross of appeal are incompetent as they complained against the interlocutory decision of the tribunal. It was submitted that the cross appeal by the second respondent cross appeal was filed out of time, same be challenges to interlocutory rulings or decisions made in an election matter. The PDP and Aswen Godalo said the cross appeal ought to have been filed within 14 days as mandated by paragraph 6.1 of the Election Judicial Proceedings Practice Directions. The appellant submitted that where the ground of interlocutory appeal is incorporated into a main notice of appeal, it is incumbent on the cross appellant to ensure he files his notice of cross appeal within 14 days so as not to find his interlocutory appeal to be out of time. On the contention that the record of cross appeal is incomplete, the Court of Appeal submitted that it was strange and misconceived stand as there is no requirement under the Election Judicial Proceedings Practice Directions for a cross appellant to compile a record of appeal, let alone to talk of the record being incompetent or not being complete. That the cross appeal and appeal in an election matter is taken as one appeal and cross appeal is entitled to rely on the main records, and that even if the records were incomplete, it did not affect the live issues in the cross appeal as relating to grounds 1 to 4 of the notice of appeal. In the judgment, the Court of Appeal told the appellant counsel that there is no requirement for the cross appellant to compile and transmit a separate record of cross appeal or cause same to be compiled and transmitted, let alone conceived or raise the question of incomplete records of cross appeal. On the issue of the BVAS, the Court of Appeal said it is true that one Mr. Samuel Itodo brought in BVAS machines and identified them as the ones he used at the election to the governorship seat of Edo State in question, to the extent that the tribunal alluded to certification as a true copy, saying that it was wrong as the BVAS machines are not copies of documents nor can be certified. They were, however, admitted having been produced as hard or real evidence by a person who had not seen or seen those who used them. The court said the mere and bare existence of the 133 BVAS machines as exhibit did not aid the appellant's case, nor could it be prejudiced the cross appellant's case, as the content thereof has to be proved only in strict conformity with Section 84 of the Electoral Act on computer-generated evidence of witnesses, identifying the certified content produced, therefore the results, and speaking to them directly, and to be cross-examined on them. According to the court, Section 81(1) of the Evidence Act states that it is clearly mandatory and applicable to the content of a computer such as BVAS machines produced and tendered. The evidence on the workability and state of the BVAS machines shall not be by the certified alone, but by oral evidence of how it was obtained and operated to generate the results. The result must further be testified to by appropriate persons as either the maker, custodian, or participants who could identify and make comparison with other issues also identified properly. It maintained that dumping an address of counsel will not validate or make admissible evidence nor produce in accordance to law on which authenticity is not verified, saying that it is not permissible. The BVAS machine, though a document in law, is real evidence which only can be proved in proceedings by evidence of a witness who may be cross-examined on it. The tethering of the BVAS machines from the bar was not shown to the pursuant to the consensus of the parties at the pre-hearing session. It must be tendered only through a witness whose statement on oath had been front-loaded and filed along with the petition. Further, the appeal court said the answer elicited from the said Samuel Itodo of INEC that he had no physical access to the BVAS machines during the election, yet he identified exhibit PJ1 as the BVAS serial number and was able to identify exhibit PDC1 to PDC56 as the BVAS extract tenders, exhibit PJB identified as the certificate of compliance, and described the document extracted from the BVAS as screenshots. Based on this, the court said the BVAS and extracted documents in the circumstance, even if relevant, had no probative value and the admissibility was rightly challenged. The court said the BVAS was identified by a person who could not be trusted on the veracity of the exhibits and usage and content thereof, including retriever, saying that the PDP and Aswen Godalo was not the best person to tender the document through their counsel as purportedly done, as that only ratified their existence as one of the documents parties had agreed to tender, but had not been tendered properly and by the right person or circumstances to be admissible. The court said the confirmation order made by the tribunal admitting exhibit PP
DD1 to PP DD133 in evidence is in the circumstance insupportable and is found to be invalid, having been done contrary to clear provisions of statute which is extant. He concluded by saying that the order of the tribunal confirming the admissibility and admission of the BVAS machine in evidence occasioned miscarriage of justice and was set aside, and thereafter expunged the records of the BVAS machines from the records of the tribunal. Also, the Court of Appeal said the tribunal arrived at a perverse decision when it compared Section 134 of the Electoral Act 2022, which prescribed grounds for presenting a petition, with Section 51(1) and 2 and Section 73(2) of the Electoral Act. The court noted that the mere failure to fill electoral forms or fill them properly, contrary to the prescription of Section 73(2), would not be a sufficient ground capable of invalidating an election. Also, the court said whoever claims that an election is invalid in his petition cannot at the same time demand to be declared the winner of same election he condemned as invalid. It also stated that from the provisions of the law, it is instructively clear that the petitioner is required to state clearly the facts of the election petition, the ground on which the petition is based, and conclude with the relief sought, which must be related to the ground of the petition, and said it is the solemn rule which the appellants broke with their reliance on the first grant in their petition without stating the relief thereof. The three-man justices of the Court of Appeal thereafter affirmed the judgment of the Justice Wilfred Kpochi-led three-man panel of the Edo State Governorship Election Petitions Tribunal.
As Edo people await what will likely be the finale in this legal battle, one thing is clear, that the court over time have maintained its stand that they are not cheerful giver. The court is not a cheerful giver. The court can only give what has been asked for. Things that stood out in the judgment of the appeal court and the lower court tribunal is that the petitioner and of course the appellant in this instance could not substantially prove the case of non-compliance. And of course they were not able to call polling unit agents, INEC officials, or even voters to testify, and that substantially affected the petition. And now we're looking forward to what will happen in the Supreme Court. But don't forget that the appeal court have also said that the temporary admissibility of the BVAS machine was wrongly done by the tribunal, and that should not have been the case in the first instance, because tendering of such documents should not be from the bar, but from witnesses who before now or before then had front-loaded their statement on oath. Well, we're just here waiting, and every Edo people, interested parties, both at home and in diaspora, are waiting for the next line of action. And it's going to be a couple of days from now that the Supreme Court is expected to give verdict in the appeal by the PDP and its candidate, Dr. Edo Election. And that's a special report for today. Thank you so very much for watching. My name is Best Orito.